Hello, everyone. Welcome to the IPV Domestic Violence TBI Task Force, created in 2018 to have a safe space where brain injury professionals with their knowledge of brain injury and those with a knowledge of domestic violence learn and trade back and forth information. We have over 441 members in 14 countries now. I just wanted to share with you what I think is a very cute picture. In Toronto in 2019, we had our first get together, and you can see that group at the top. And then we just had a get together at the Ireland meeting of IBIA. And so that's the Pink Concussions task force. And it was really fun. We just made it a social and just invited everybody to share what they were doing. Really fascinated group. So hopefully Calgary is the next meeting, and hope to see you in Calgary so we can meet in person. So with that, I'm going to switch over and invite someone very familiar to this group, Paul, to introduce himself, and Quinn.
Wonderful. Thank you, Catherine, and thanks for having us on today. So my name is Paul Van Donkelaar. I'm a professor in the School of Health and Exercise Sciences at UBC's Okanagan campus in Kelowna, which sits on the unceded ancestral land of the Silks Okanagan Nation, and I'm here as an uninvited settler guest. Quinn, do you want to do your introduction and land acknowledgement?
Hi, everyone. I'm Quinn. I am a PhD candidate at the University of British Columbia in Vancouver now, and that is on the unceded ancestral territory of the Musqueam, Squamish, and Tsleil-Waututh people. I'm very grateful to work and play on these lands.
So we're going to chat a little bit today about a study that Quinn did for his master's thesis under my supervision, and along with some great co-supervision from his current PhD supervisor, Judy Illis from UBC Vancouver, and Dina Sima Neto, who is in the School of Sociology here at UBC Okanagan. And so it, as the title suggests, and if you had a chance to look at the article beforehand, it's about concerns around how a brain injury screening or diagnosis might be weaponized in the context of legal proceedings. So next slide, we'll just give a bit of context. So don't really need to go into too much depth in all of this for this group, but we know that about 33% of women will experience intimate partner violence in their lifetime. In a lot of cases, that can be physical intimate partner violence. And it's hard to get exact knowledge and information on the incidents. And so we rely on lab-based assessments and other assessments and reports of women who've experienced physical intimate partner violence will very likely also suffer a brain injury, either through head impacts or a strangulation, or both. And this is a new area of research, and one of the things that we've been pushing really hard for folks to do who work in the women's shelter sector and other sectors that provide support for people experiencing gender-based violence is to screen, or in some other way gain some insight and acknowledge and provide support for the potential for brain injury, one or more brain injuries, to be part of the experience. And so in the context of whether it's a healthcare setting or a community health setting or a community support setting, having knowledge of brain injury and using that knowledge to provide appropriate supports is a positive thing. Next slide. So it's a growing area of research, and there's a number of folks on the call that have been contributing and adding to the knowledge around characterizing a brain injury in the context of intimate partner violence, and then creating and implementing and evaluating various supports that take brain injury into account. So that's all well and good in the context of general healthcare and general gender-based violence supports. But in the background, in a lot of the conversations that we've been having, is this concern that screening and or a diagnosis of brain injury due to intimate partner violence has the potential to be weaponized in legal proceedings. So Quinn took on the challenge of trying to study this, and I think did an amazing job. And so I'm going to pass it over to him with that introduction, just to have him go through the details of his study. So take it away, Quinn.
Thanks, Paul. Yeah, and this slide might be a little bit repetitive of what Paul just said, but I really like this figure to sort of paint a picture of what we're looking at and why it might be important. So the advancement of this research that Paul's been talking about in IPVBI, it does provide an exciting avenue to sort of an improved understanding and diagnostic tools and treatment options, which ideally would lead to an improved quality of life, right? But all of that does happen within something that I like to call throughout my master's thesis the healthcare silo. And often the decisions are made within this silo without the consideration of other contexts. The implications of this diagnostic information in other contexts of life, represented by this highlighted box, does deserve careful consideration prior to widespread implementation of brain injury screening practices. And this is especially true when focusing on marginalized populations. So, for example, what implications does this information hold in a court of law? And what can scientists and healthcare professionals do to ensure that their diagnoses and the treatment plans they're giving out do not cause harm in other contexts? So to give a little bit more background on the problem, stigmatized health information does have a history of legal implications, and usually we're talking about mental health disorders. And I'll also note at this point that this is in the Canadian context, but in terms of the legal context, it does translate quite well to the US as well. So what it comes down to in family law is questioning someone's capacity to parent based on their health status. So this could be based on their depression, or based on their anxiety, or based on their brain injury. And although there is no current literature surrounding IPVBI and family law, there is some adjacent literature that's important to take note of. So there's something I call the family law triple threat. And this is it's three things that family law really latches onto and investigates when they are present in a case. All of these things are highly comorbid with both IPV and brain injury. And as mentioned, with mental illness, the question becomes whether one is fit to parent. Now, just because you have a mental health disorder doesn't mean you would be deemed unfit to parent. If there is a validated treatment and you can demonstrate a period of stability, it shouldn't factor into this decision making at all. However, literature does show that courtroom distress can exacerbate symptoms, making it much more difficult to demonstrate stability to the courts, leaving clients in a vulnerable position. And that brings me to the purpose of my study, which was to explore the effect that brain injury might have on parenting disputes for women who have experienced intimate partner violence related brain injury. And there was this sort of overarching objective to deliver ethical recommendations based on how brain injury information may be used in legal proceedings. So, the goal of the project wasn't really to say groups like SOAR need to shut down and not do this. The goal was to provide some recommendations on how to mitigate the risk of that information causing further harm. So to do this, I had 12 participants, all who were Canadian family law lawyers, and I recruited them through the professional networks of both myself and the other members of the SOAR team. We had 9 women and 3 men, and I did in-depth semi-structured interviews with them using something called the Contrastive Vignette technique, and I'll explain that a little bit more in a moment. For the ethical analysis, I use what we call a pragmatic ethics framework, and what that means is rather than just theorizing about the ethicality of the situation, the goal of the analysis was to give recommendations on how to mitigate or eliminate the harms of screening for brain injury in women who have experienced intimate partner violence. So I created this table to just really simply show how contrastive vignette technique works. So what I did was I wrote 2 vignettes describing 2 hypothetical clients, and they're represented as client A and client B. And as you can see in the case information column, both women were identical in these characteristics, and where the contrasting detail appears is in the third column under brain injury status. So client A had no known brain injury information, whereas client B had a brain injury likely due to IPV. So what I would do was present the client A vignette to the lawyers, followed by some questions surrounding their strategy for this client. And then I would present vignette B with the brain injury in there and ask very similar questions and see how their strategy might change, if they're prioritizing the brain injury, if it's a factor at all, and then would dive into some of the more the nitty gritty of that as well. So onto the findings and the discussion of those findings. So this figure represents all of my findings. In the interest of time, I will focus on the sub-themes that are directly related to IPV-BI outlined here in red. And if we want to talk about sort of the more broad themes of Canadian family law, we can do that in the Q&A. So the first sub-theme was education. It became clear through the interviews there was a limited understanding of both intimate partner violence and intimate partner violence related brain injury by the legal profession. Where there was access to education about IPV was through continuing professional development seminars. However, it was acknowledged that IPV was a relatively new sort of specialized topic in these seminars, and they're also not required for everyone. So it was sort of the lawyers who were interested in educating themselves specifically on this topic would take it, but it's not required for all lawyers and judges. So as such, it's unsurprising that most of the participants reported no formal education on IPV, dating all the way back to their law school days, or how to handle IPV in family law. Like there's no standard way that they handle allegations of IPV in family law, which was concerning given sort of the self-reported estimated rate of IPV amongst their cases at any given time ranged from 25 to 100%. So there wasn't a single lawyer that said, I never have cases of IPV in it. That they all had them, and it was all the way up to 100%, which were lawyers strictly focused on violence against women. My second sub-theme was around capacity, and that is in reference to either a woman's ability to give and receive legal instructions because of any potential neurocognitive deficits caused by the brain injury, or more importantly, in an attempt to question the woman's capacity to parent. And this weaponization of IPV-BI in parenting disputes was consistent among all participants. So every single participant stated that they would expect the opposing counsel, so counsel for the abuser, to use the brain injury as a means to challenge the woman's ability to parent. Now, interestingly, participants also said they would do the exact same thing if they were representing the alleged abuser. And this is despite sort of acknowledging as they said it, how absurd that sounded, that they just sort of said, yeah, someone's going to do this and it's awful. And then, a few minutes later, they said, well, I would do the same thing. And so this weaponization of brain injury mirrors the past experiences in family law where stigmatized health disorders like depression or anxiety were used to undermine or minimize a woman's parenting capacity. The last sub-theme is causation. And so the court of law typically relies on physical evidence, which is often difficult for women and lawyers to provide because of the nature of IPV and IPV-BI. And therefore, in the absence of physical evidence, this often becomes a situation of testimony and hearsay. And in these cases, women are either not believed, or their experiences of violence are minimized, or the courts acknowledge the IPV and that it happened, but dismiss it as strictly marital conflict and deem it irrelevant to the best interest of the child, and therefore irrelevant to the parenting dispute. So ultimately, this means that linking IPV to BI is very difficult, and the courts will rely on expert testimony in regards to the brain injury. So specifically, they'll defer to physicians. And this can be a problem because it assumes all physicians are well versed in the complexities of IPV-BI, which may not be the case. So from this data, I formulated my ethical recommendations. The first is for organizations who do IPV-BI screening to have expert allyship, meaning have physicians on board with the teams who are willing and able to advocate for women in court if need be. Next is ensuring that women have access to trauma-informed legal teams. And you know, sort of a broader recommendation is to implement mandatory education for lawyers and judges on the topic. If we know that it is this common, not having mandatory training surrounding IPV and how to appropriately address that in court, it seems silly, quite honestly. We can also anticipate skepticism surrounding a woman's parenting capacity if she has a brain injury. So let's incorporating a sort of a parenting assessment in these screening tools to show that the brain injury has no significant impact on her parenting abilities. And last, transparent informed consent. So one of my participants told me that information is power, especially in legal proceedings involving intimate partner violence. So being transparent about the potential for this information to be weaponized will ensure that both the lawyers and the women are ready for that and can prepare for it appropriately. With these recommendations, it's also important for me to emphasize the need for readers and organizations to apply these recommendations through an intersectional lens in their context. So what that means is careful consideration of a client's or participant's social and political identity is crucial in ensuring the most ethical navigation of intimate partner violence and brain injury screening, research, and family law practices. This brings me to my conclusions. So IPV-BI does leave women legally vulnerable, and that's for a few reasons. So the lack of legal precedent, so we really haven't seen this inserted into the criminal justice system yet. The inadequate understanding of both intimate partner violence and brain injury by legal professionals, and the difficulty in establishing links between intimate partner violence and brain injury. And so this in turn puts the best interests of the child at risk. I would like to highlight that the brain injury is not the problem here. The problem is inserting it into a system that is ill-equipped to deal with it appropriately. And therefore, IPV-BI screening does deserve careful ethical legal consideration, at minimum to equip women to navigate the system while we wait for some sort of broader systemic reform. And I'll pass it back to Paul here for some next steps with this information.
Awesome. Thank you, Quinn. And thanks for taking that on. Quinn does a way better job of presenting this work than I do because it was his everyday existence for a few years. So yeah, so what comes out of all of this? Quinn's moved on to do a PhD on a related but not completely overlapping topic, and so we're keen within the SOAR project to develop this further and act on those recommendations. And so one of the things that we're hoping to do over the next year or so is work with legal advocacy groups here in British Columbia who are involved with supporting women experiencing intimate partner violence in legal settings, to basically work through those recommendations and determine priorities both for research in the kind of the ethical legal space, as well as potential practice change. So what would it look like to support women experiencing intimate partner violence and brain injury through a brain injury lens, amongst others. And so we're hopeful that some of the recommendations that came out of Quinn's work and are identified in the paper will likely be prioritized amongst these advocacy groups. And one of the key kind of outcomes of that would likely be more training, more knowledge and awareness raising about brain injury as a result of intimate partner violence and how that plays out in the context of relevant legal professionals and their allies in the work that they do in providing support. So stay tuned, still lots of work to do, obviously, in this space, and a really interesting experience working with Quinn and the rest of the supervisory team through this. It was truly interdisciplinary. The brain injury part was kind of in the background as a foundation, but the kind of ethical approaches and methodologies that were used were a great learning experience for all of us, I think. And so really wonderful to be involved in this project, and happy to take any questions at this time.
Thank you both for exploring something that we all were very interested and concerned and wanted to find the answers, and currently what stands and directions. First, I'd like to ask anyone that the other 5 women that help run our leadership group to ask their questions first, and then we'll move to the floor. Eve, you have your hand up.
Hello, hi, and thanks, Quinn, for that study. And hi, Paul, nice to see you again. So yeah, I think that one of the things, I mean, I wasn't sure. I got a text right when you were talking about some of the implications, but and you were saying knowledge is power. So I'm assuming you're not saying we shouldn't screen women because then it could be used against them. And if so, I would agree with that, because there are just so many other reasons I would think that women need to know this information, because, as you said, knowledge is power. And without that, they're sort of operating like a car with 3 or maybe 2 wheels. So I think I got that right. So, but correct me if I'm wrong. And so am I wrong on that, or did I get that right? Okay,
Right.
okay. I just wanted to make sure, because sorry, there was a ding. It just that you said something and I was just like, what? And so anyway, so the other question, the other thing I had was, and I've found this kind of interesting, is 2-pronged. And I feel like I'm kind of stunned at how, pardon my use of the word, but ignorant lawyers can be when it comes to incredibly basic information. IPV is not rare. There's nothing new about IPV. It's everywhere. And if people are saying they've dealt with it all the time, it's kind of astonishing to me that not more is done, except for the fact that there's very little money in it. People don't make money studying IPV. People can't get a case studying IPV. Like, I can't go and sue that guy who beat your brains in because you don't have any money. So unfortunately, one of the downsides for lawyers investing in this idea is the fact that they can't make any money off of it. And I've had lawyers actually tell me this. So I'm not just making this up. I mean, I'm not going to say every lawyer is like that. But so I think there needs to be some incentive for lawyers to learn about IPV. The other thing is that one of the things I think your study really showed was not necessarily about brain injury in IPV and brain injury screening, but about IPV more generally, and about any emotional and mental health condition. I had a woman reached out to me and she said, basically her kids were taken away from her because of the PTSD diagnosis she was given because of the abuse that her partner had given to her. There was no dispute over what the partner had done. He had clearly traumatized her enough so she had PTSD. She went to the treatment, everything, and filled it. Her clinician said she was fine, and yet she still couldn't regain custody of her children, because then she would have had to give up the address to where she lived, because that's part of the deal, even though she had this special card that says she didn't have to. He had just gotten his gun back after being in jail, and so she was afraid he was gonna come and shoot her, but yet she could not get her children back because of that. So that has nothing to do with that brain injury at all. But I think brain injury is just one more little thing to add. So I want us all to remember that, when we're dealing with IPV, I think that there are so many things that are weaponized against women in that situation. The brain injury is just one of a whole bunch of them. So I just really want to make sure we don't shy away from screening for brain injury, or letting women know we think they have a brain injury, or maybe that they might have a brain injury because of this. And I'm glad you said that, but I have heard in the past people say, I don't know if we want to tell women this because blah, blah, blah. And then I basically retort with what I said. The other thing, and then I'll shut up, I'm sorry, but this is like one thing that I've just been like, I feel like it's just so, I mean, when you meet these women and you see what happens, it really gets to the core of you. And this has just been my experience. Like when I've had women coming to me with these experiences, which is just so horrible. The last thing is, so what if you have a brain injury? So I sustained a brain injury riding my bike or riding my scooter, whatever. It was a mild traumatic brain injury, but whatever. I had blood coming out of my head, whatever. There's no, would any judge ever say, take her kids away because she just had a brain injury if my husband and I were suddenly getting a divorce? I don't think so. So I don't think it's just the brain injury. I think it's the fact that it's an IPV situation and that women who are victims of partner violence often get stuff weaponized against them because of the misogyny and the sexism in the system. That last part's just my hypothesis, but I don't think it's just the brain injury, because there are many cases of brain injuries, and maybe I'm wrong. Maybe bike accidents do get weaponized against people in divorce cases, but that would be an interesting study to look at. So with that, I'm sorry. I'm just so, this just, as you can see, like my blood is boiling when I think of how, and I'm so glad you did this study. I think it's wonderful. So thank you. And I hope you don't see me like I'm not appreciating it, because I think it was a wonderful thing to do and it needed to be done. But the legal system for me is just choking. I mean, well, strangling and women who are experiencing IPV. And I don't know. I think there just needs to be such an overhaul in how IPV is presented in the legal system. Sorry, that was my little rant, but thank you again.
No, thanks, Eve. It's always nice to hear your point of view as a pioneer in this field. But yeah, I think your comments captured exactly one of our conclusion points there, is that the brain injury is not really the problem, it's the system that it's being inserted into. And so I think, like Paul said, we sort of used brain injury as a foundation to sort of expose how messed up the legal system is. And the problem is very much the sexism and misogyny that sort of seeps into the Canadian legal system and has been there forever, as well as racism too. Because when we brought up, how is this different if we change the race of the woman in the vignette, it became even more of a nightmare for Indigenous women in Canada, or Black women, racialized women in general. So yeah, I think your points are very important to make, right? Like, this isn't necessarily a problem with the brain injury, it's a problem with the legal system. But if we're working in IPVBI, we should make sure that we're doing it in a way such that this isn't just another way for women to be victimized by the family law system in Canada or the United States or wherever it may be. So yeah, very well taken. I totally agree with everything you said.
And just to say, actually, I think your paper is great, because then I can use this, like in a presentation I had, I said, I basically used this to say, yeah, we know that bad things can be done. So when if we do identify brain injury, we say, this is for your information. We may or may not want to share this with the legal team. And so that way they have the information, but it doesn't necessarily need to go any further, because now we know that the legal team may use it in ways that it shouldn't be used. So I think that your paper is great, and that it sets this up and provides more information for saying we have to do our due diligence to get this knowledge, whatever's going on. And then this paper allows us to say, okay, well, how can this hurt people? And then we're going to compartmentalize this potentially if we're in that situation. So thank you. Appreciate it.
One last thing I'll say, that in terms of sharing it with the legal team or not, that's not up to us as scientists. It's certainly not up to the women either. One of the motivations for this study was reading case law where an entire transcript from a woman's counseling session was read out in court, where she had mentioned sort of ideas about suicide and depression, and that was used to take her kids away. So there's no real safe way to have the stigmatized health information and it not seep it, like make its way into a parenting dispute. Because when there are children involved, and this isn't, I'm speaking to the Canadian context, but my limited understanding of the States is it's very similar surrounding health information. If there are kids involved, they'll just get it. They can get it. It doesn't matter. There's no practitioner patient privilege when there's kids involved in a parenting dispute. So if this information is available, if we've connected women to health supports, social supports surrounding this brain injury, the lawyer will find that and they will use it. So that's the idea behind like transparent informed consent. We want to get ahead of this. We want your lawyer to know about this so that they can be prepared. And most of the lawyers that participated said that if they have knowledge of this up front and can prepare documents and prepare witnesses, this could be something that's easily squashed. But if they're caught on their heels by this, if the woman doesn't share it with them for fear, out of fear, basically, it could be really damaging because they won't have anything prepared to in response. So yeah, just another really messed up thing about the legal system. You can't have health information that doesn't make its way into it.
Yeah, I guess part of what I was thinking was if you're in a shelter, so you may not document it within that shelter context because you know that this could be weaponized against them. So it's basically discussed between you and the shelter worker, but you don't ever put it down because you know that can be used.
Right.
But the thing you said about the client and being able to say something in a counseling session, that is shocking. And I wonder if that's true. It might be if kids are involved in the situation, because usually patient-client privilege, is like, it doesn't matter. You have the sanctity of that, but it sounds like certainly not in Canada and maybe not in the US either. But yeah, I would say like, it's just, you don't even want to get it written down anywhere is the point. That's sort of where I would draw the line there if we think there's any legal battles going on. But yeah, one more level of complexity. And thank you again. It's really super helpful. And I really appreciate you doing this work.
Thanks.
I wanted to give Kate Iverson a chance to ask her question. Kate, can you unmute, or would you like me to? Yeah. Hi, Kate.
Hi. Thank you so much for this presentation. It's so important to start this line of research and to go from here. So I loved hearing every second of it. I had just written a comment about, I loved, this idea of transparent, informed consent and kind of talking to people about the pros and cons of bringing something forward. Or for us, we're thinking about when we screen, do you want this documented in your medical records? Would your partner have access to it? Are there other reasons that you wouldn't want some details or any of it documented? It's just such an important thing to put on people's radar. I know just like historically, physicians are trained to document every single detail in the medical records, not knowing that can have unintended consequences for some people. So I hope that was just a really strong takeaway for me personally. I don't know if others had thoughts or reactions to that too.
Thank you, Kate. Did you want to comment, Quinn or Paul, and then I'll call on Angela?
I was just going to say, yeah, that's a really good point. And, I think it's really powerful to confirm the autonomy that a patient or a woman might have in this situation, right? I think it speaks even broader to the medical system, like ensuring the patient knows they have autonomy in that situation and control over their health information would do wonders for all patients, but especially women in cases where IPV is present. So yeah, surrounding the transparent informed consent, not only that it could be used, but there are options in terms of reporting this or not, how we document it, and the supports that you can get maybe without strict documentation. Yeah, it's a really interesting path to go down. Thank you.
Angela?
Oh, I just wanted to say, well done. Great presentation. I was Quinn's thesis examiner, so I had my opportunity to ask my questions. So I'll pass it on to anyone else, the people who came to join with us for this session today.
Rachel, did you have any questions?
Hi, everybody. I'm Rachel from Ohio, from the Ohio Domestic Violence Network. And I do think very much for people who have worked in domestic violence a long time, just the legal system is anything that can and will be used against you will be. So I think that that's just a concern with so many issues. But you know, I do think that there's a couple of other kind of when thinking about documentation and what all of that can mean or can't mean. You know, I know sometimes one of the big problems also with legal concerns is that there isn't anything documented. So like the lack of documentation can also be a challenge for survivors in many, many cases. I thought about this a little bit more when thinking about just the access piece, about how when people have potential brain injuries and also are traumatized, and recognizing that the legal system is a very, very just triggering experience when you think about having to share stories, participate in a place where somebody who has hurt you was right there. I mean, there are many people that say you couldn't have kind of design a more triggering situation if you tried, but really thinking about how that could help a lawyer really understand how to best accommodate for some of those needs related to possible brain injury and or trauma that will allow them to be able to better participate in their legal proceedings. So, you know, I think that that's another, we have a new court in our area that for CPOs, for civil protection orders, that has like separate rating rooms and those kind of things. So, you know, I think sometimes what can happen is the trauma and brain injury impacts can make it really, really hard just to participate in any kind of legal action. And if that's something that you want to do, being able to accommodate for what those needs are, how do we need to interview differently? How do we prepare you for any kind of other type of cross-examination or what that will be? I think that that's just another, that I think that there are ways where knowledge and awareness about brain injury by people working with survivors can just make systems more accessible, regardless of whether it gets brought up. We do have lawyers that do advise don't even bring up domestic violence as any kind of part of any kind of family court proceedings unless there is evidence, because that will probably be used against you. So again, getting back to that whole medical documentation, sometimes that medical documentation is what you need if you don't have police reports or those kind of things. But having police reports and those kind of things doesn't always mean that things work out as they should. So thanks for bringing up all of these issues. It's a lot to think about. The legal system is just really, really, really difficult for survivors. And I think we have a legal program here in Ohio that really works on kind of training lawyers statewide to deal with not only domestic violence specific cases, but to have that practice experience in practicing domestic violence law and what it is that that's going to look like. So I think that that's a good opportunity in thinking about those things. But thank you both so much for your presentation.
Thanks, Rachel. Yeah, just in terms of specific practices to protect survivors in the court proceedings, I know a few of my participants strictly do violence against women work, and so they talked a little bit about some of the strategies they might use. One of them being doing the entire proceeding without the woman present, because unless it's absolutely necessary, they said, nope, there's no point in the woman being there and having to face their abuser and go through that whole traumatizing experience. And it usually works out better, more in the woman's favor, if she's not present and there can't be any sort of antagonization or exacerbation of symptoms of mental health disorders or, you know, PTSD, things like that. And then another thing, like you mentioned, sort of the separate reading rooms and even virtual, like having women sort of zoom in if they're required to be present. Those sorts of strategies I've heard from some people who are strictly working in domestic violence or violence against women. So there are some people aware of strategies to mitigate the harms that survivors encounter in the legal system. There just needs to be, you know, some widespread education for lawyers. And, you know, even speaking back to sort of Eve's comments surrounding there needs to be incentive for lawyers, or it just needs to be mandatory. You know, like if you're working in family law, it's just mandatory, and it should go all the way back to law school. You know, I was appalled that when asking about law school, they're like, no, I don't think intimate partner violence was never mentioned. They would say that almost right away. And some of them would him and haw and think about it and be like, no, I don't think so. You know, even in their family law specific electives that they would take in their upper years, they don't mention intimate partner violence. And we had people that, you know, went to law school 20, 30 years ago, and we had people that were fresh grads, you know, had been only practicing for 5 years. So to see no development in sort of the curriculum surrounding intimate partner violence and family law is shocking.
Nat, you have a question?
It's possible that I didn't capture all of the pieces of the presentation. I'm really sorry. The closed captioning is just not working. So it's hard for me to understand all of the things that people are trying to communicate. But I think that one of the tools that's really important is for the hospitals, the medical providers, the court system, the administrative office of the courts, or AOC, to really understand how to use all of the tools that are about ADA or wherever you're living or you're working. What is access? It shouldn't be this secret knock on the clubhouse door to get in and know that you're going to understand what it is that's being communicated in all of the settings. And I think that that's equally hard for hospitals, for nurses, for doctors, for lawyers, you know, all of the pieces, all of the places need to understand more and more about what is access and how are we, you know, successful with it at every juncture. And I think that we need to remember that that is a big role that we need to show in what we do. Thank you.
Paul, do you have any comments? I know I'm hogging the Q&A.
No, it's all good. I guess one related to all of this conversation, and one of the things I think your study identified was the lack of legal precedent. As you know, there's nothing to set the foundation on which subsequent cases could consider in the arguments that are done. However, there are some taking place, and so in British Columbia, I think last year or the year before, there was a civil case that was successfully brought for exactly this situation. It was mainly due to strangulation. I think it was entirely due to strangulation, and there was enough clean evidence, both in terms of the initial injury and the subsequent effects that it had on the woman's capacity. You know, not in the context of parenting. I don't think there were kids involved, but more just in life and the challenges that she was now facing. And it was successful. And so, at least in a civil court setting, that there is that precedent now, at least in British Columbia. I'm not sure if elsewhere in North America or around the world, similar isolated cases are starting to become, you know, reality. But I think the more of that happens, the more we'll be on the road to being able to have this be something that is, you know, brought to bear in both civil and other legal proceedings.
Thank you, Paul. And if you're from another country and you have something that in your particular country that's working well or even working at all, please let us know. Autumn, you have your hand up.
Yeah, hi. I work as a legal advocate at a domestic violence center, so I work very closely with an attorney who represents many of our victims, and he's been willing to learn so much. He takes a lot of the same trainings that we do, and it's great, but I've noticed that sometimes the judges fall short when it comes to understanding IPV, not just the lawyers. So I feel like the judges should go through the training as well. I don't know if I'm in the state of Maryland right now, so I don't know if it's different in other states or not, but in Maryland so far I've noticed that there are some victims that get more traumatized going to court just for a protective order than they were even just from the abuse they sustained, because judges will sit there and basically just either tell them they're not credible or something like that. So it's really hard, especially in this area that I'm in. I'm in a rural area where there's a lot of drug use, and offenders will drug their victims sometimes when they go to the hospital and then have no recollection of what happened, and under whatever drug they were drugged with, tell the forensic nurses not to take images, nothing like that. But then later on realize, I don't know why I said that, like I was drugged. It makes it really hard for the legal system to rely on the medical professionals to even provide any of that, because I mean, yeah, it's like a never ending cycle, like between the education that needs to be had between not even just lawyers and judges, but just like emergency room staff as well, whenever there's drugs present.
Yeah, thanks, Autumn. When I say there needs to be more education for legal professionals, judges are number one on that list essentially, and the lawyers I spoke to essentially said that as well. Especially those that work specifically in domestic violence. They said, well, I understand it really well, and even when I relay all that information, the judges just aren't receptive to it. And they sort of said exactly what you said. There seems to be a lack of understanding that is so ignorant that it becomes incredibly harmful. And there's zero flexibility even in being receptive to the information presented to them. So yes, yeah, when we talk about educating lawyers, I think it's, to me, it goes without saying, like, the judges are number one, like they're the ones that usually end up making the decision. So like they need to be prioritized for sure. And yes, there are so many factors that makes it a mess, especially when drug use comes into play. So it's very unfortunate.
And I appreciate the comment, Autumn. A large number of us on this call were a part of the New York Times article last spring, where one of the most telling comments was a judge that emailed me after it to say that in 2-3 decades on the bench, doing countless numbers of restraining orders, either granting them or not granting them, he had never considered brain injury in the domestic violence cases. And he was kind of horrified that so much time had gone by and he had not looked at the symptoms that were visible in these women and interpret them in anything other than, definitely not interpreted according to brain injury. Eve, you had a question? We've got about 8 minutes left.
Yeah, I just wanted to say one, or actually two quick things, but one of the things I did want to ask was when Quinn was talking about research, and so you're saying that in a patient client setting, a judge or a lawyer can get that information when a child is involved. So are you also saying that a judge or a lawyer could get information from a study? Because we have confidentiality, certificates of confidentiality, which presumably make it extremely difficult for anybody to get that. So I don't know if we have something that Canada doesn't, or if it's easier. I mean, I always tell somebody, like if somebody has a court case going on or something, I always say, I can't 100% guarantee this. I said, I've never had it happen, but you need to know that, if you tell me this, I can't 100% guarantee that somehow this won't end up in the wrong hands. I said, we have a certificate of confidentiality, but again, there's ways, whatever. I don't know if rules change or whatever. So I try to be careful, and I'm always a little nervous if there's any type of situation like that going on. But I wanted to know if you knew any more specifically about that. I mean, albeit in our country, so maybe you don't, but in your country, is it easy to get research data as a lawyer or a judge?
Yeah, this is something that I don't know. So the way I've spoken about it is that normally the goal of organizations like SOAR is to connect women to supports for brain injury and mental health disorders. So my idea was, through that, if they get connected with counseling services or any sort of medical supports where there's documentation, that for sure will be like a lawyer will find that. In terms of the research data, I don't know, and maybe Paul might know more about sort of.
Lori is commenting here, just in case no one else saw it. She says, if the expert is privately retained, the information cannot go to the court without authorization of the party who retained the expert. So that's good. Okay. So then that would be, that's a good thing for us, finally, a single win. But nonetheless, there could be issues. But I really appreciate your point that, I always thought there was sanctity in a clinical session. And now I realize that that's absolutely not the case. So that's definitely good to know. And then the other thing I wanted to say is when we were talking about like Katherine, you mentioned it, but like I know Julia Dougherty's on the call right now. If she knows of how the law works in terms of IPV in France or in Spain, where she was recently. I mean, so we do have people in different countries who could sort of feel out the legal system to see if it's any different. I mean, or maybe somebody here knows, but I guess it would be interesting to know if, Canada and the US are in the dark ages when it comes to the legal system and IPV, or if it's rampant. My guess is it's rampant, but it would be good to use the resources and the people we have here to see if they could find out more. Thank you. And Nat Dean is quoting something.
Yeah. Nat, I'm going to try to open Julia's mic. And Nat, you want to say something before I look for Julia?
I put, this is Nat, I put into the chat link to a column. Well, you guys don't need sign language. I'm sorry. It's just hard to stop. There's a document out of Colorado that I put the link in that talks about various different ADA accommodations for various types of disabilities, and also when exceptions can be made to appear differently within the courtroom, i.e. video testimony or other reasons, if the disability is identified. And there's nothing wrong with identifying the disability, because that may be one of the avenues for the person to receive later financial resources and accommodations that will help them live their life in a more full or robust manner. Thank you. And with a quote I put in that was kind of long was from that document about an accommodation in the courtroom. Colorado's done a great job of even a flow chart of what do you need to do to create this reasonable accommodation. Thank you.
Julia, you should be able, this is just a regular Zoom call. You should be able to unmute. While Julia's working on that. Lori, did you have anything you wanted to add? Because I thought your experience was fascinating.
If Julia's on the phone, she can unmute with *6.
I think she's not. Lori, did you want to mention anything? There's been some very interesting comments in the chat too, if you haven't had a chance to read the chat.
Hi. Yes, I'm happy to talk about our experience. We are actually hoping to do a judges training in the child welfare system in California in hopefully the end of, sorry, I was just checking I wasn't burning my dinner, so I'm a little out of breath. Sorry. So yes, we are hoping to do judges training at the end of 2023, the beginning of 2024. We're working with NASHA to create more of a robust TBI awareness within the child welfare system. And we have actually litigated it in children's court. We are a trauma-informed system, so everybody knows what IPV is, but nobody knows that it can lead to TBI. So we did have a successful outcome with a client who had a documented history of hospitalization of TBI from IPV, and she was She was a sexually trafficked youth in the foster care system who had her own children and was about to lose her parental rights on her own children. So she's in a specialty court that is specifically for trafficked youth. So it's supposed to be a collaborative court, and it still was an uphill battle to get brain trauma awareness into the court for consideration on the record. But the attorney did fight for it relentlessly, and she was able to get a totally different recommendation from the court sustained in that case. So the youth had more time to try to reunify her with her children. In addition, they had an expert witness who indicated that the compliance requirements in the child welfare system, which usually consists of the parent and youth doing counseling, anger management, DV awareness for victims, that sort of thing, they stacked it to be more brain trauma informed, so she wasn't overwhelmed by her compliance requirements. So we're using that as kind of a success case to try to show the impact that it can make within the system. But with that said, just this past week, I was brought in for a consultation on a case in which a youth who is part of the juvenile justice system and the delinquency system was just incarcerated, and she's waiting for her trial in the juvenile justice system, and she entered without a history of violence or brain trauma. And since she was being held in a period of 6 months, she has 3 documented concussions, and there is no concussion protocol in place that we're aware of in the juvenile justice system. So reading her medical records, at one point she hurt her thumb and she was given like an ACE bandage, and yet when she was told she had a concussion on 3 different occasions, she literally walked away with no accommodations. So, and in that interim, she also accepted a plea deal, which is just horrific because we don't know what kind of language they were using. Somebody posted in the chat the plain language, and we don't believe that that was in place when she accepted the plea deal. So there's still a lot of work to be done, but we are trying to make progress in California. We're the largest legal services organization in the nation representing youth in foster care. So we're hoping to maybe be a trendsetter in this area. And we thank you for all of your work.
Lori, this is Nat. Reach out to Andy Impresario with Disability Rights California. He's phenomenal about plain language and a lot of other tools. And he's in Sacramento. He's the director.
I will do. Thank you so much.
Well, thank you, everyone. I really appreciate Paul and Quinn coming on and sharing, and it was great to see so many faces in Dublin. Does Kate, Eve, Rachel, Angela, anybody have any upcoming events that they want to throw in there? Or if you want to email me, I can always send out if there's any events going on in your region, in your country, any resources you want to share, always send them to me and I can include them into the email, because we now goes out to 441 people across 18 countries. So again, appreciate everybody's presence today, and everyone will see you next month. Thanks so much.
Thanks so much.
everyone.
Great presentation, Quinn and Paul. Thanks so much. Bye-bye.
Thanks, everyone.